Yes.
Your Lordship asked me shortly before the adjournment whether we would be liable under the initial proposed directive. I hesitated because of the unfortunate words punctually and efficiently, which is the principal reason why I wanted to consider what I said.
Of course.
In essence, we say no, we would still not have been liable because the essence of our case would still apply. We didn't contract to provide guiding services at all times of the day and night, and ends acts in the circumstances of this case cannot be attributed to us by means of saying they are contractual services. But there would have been a moot point as to whether, if the court had been against me on those points, there had been any agreement as to when and how punctually and efficiently guiding services should have been provided.
Well, just on that first point, as Mr. Weir has pointed out to us, there's no schedule of which services you're going to provide and which you're not going to provide in the contract. If you undertake to supply a contract with ancillary benefits, if I can put it that way, would guidance from hotel employees, when sought by someone with whom you were in contract, would that not fall within the expected range of services?
My Lord, I say not in this case, insofar as guiding services, as widely as they need to be drawn for the purposes of establishing liability on our part. And I'm going to develop that when I come on to my issue 1A. But, my Lord, insofar as Mr. Weir says we didn't provide a long list of detailed services, that is a little bit artificial, I submit. In any case where this court or any other court is dealing with the implication of terms into a contract, it is because terms which might, with the benefit of hindsight, have helped in the course of litigation has been omitted. And what this court has to do is to construe the contract.
Implications got nothing to do with it. He says this isn't a question of implying a term into the contract. It's simply that you have agreed to provide services, and in those circumstances, one would expect that ancillary benefits, as I've rather inelegantly put it, would include receiving, not guiding services, because that gives it a sobriquet which is probably not warranted, but giving instructions on answering reasonable inquiries.
My Lord, may I come on to that in a moment?
Yes,
because I had one more point to finish up with on the travel.
Okay.
But, my Lord, my position in essence is that whether one looks at it as construing an express term, which I think is artificial in this case, or in terms of implied terms, the approach in law is in fact very similar. And that was a point in itself discussed in the M&S case, which I'll take your lordships to in a moment.
Yeah.
Lord, I wanted to finish up. I'm pushed for time, but just one further reference in the course of the legislative history, and that's to Volume 1, Tab 5, MS 329, and this is a report of the European Commission following the debate in the Parliament, in the European Parliament, the amendments to which I've referred, your lordships, having been incorporated. And can I ask your lordships to turn to MS 330, which is the first internal page of that document, and paragraph 3 on that page, I'll invite your lordships to read. That in itself again reiterates the balance to be struck between consumer and tour operator. And paragraph 4 reflects what Mr. Van Meert had said in the debate in Parliament, and for your lordship's reference, his contributions are at 1192 and 1193, where it says the Commission believes that this directive is not the appropriate place in which to include certain of the amendments sought by the European Parliament, namely those which deal with criminal acts of violence or which seek to introduce a system of approval for various types of accommodation. And you'll see from the references to Mr. Van Meert's contributions that that objection applied to both the recitals and the two recitals and two articles which I took your lordships to before lunch. Ultimately, then, thereafter, we have the directive as finally enacted. And, my lords, without taking your lordship to each and every one of them, I say that the recitals make clear this balance, in particular recitals 1 to 7 and 21 to 22, being struck between the consumer and the tour operator. And your lordships will see from Article 1 itself that the express purpose of the directive within the articles is said to be not consumer protection but market harmonisation. There is no similar reference in the articles as opposed to the recitals.
Just remind us of the MS number, please.
Yes, my lord. This is MS, so Volume 1, and it's MS 298.
Thank you very much.
Top of the page, Article 1.
Could you just give the recital numbers again?
The recital numbers, so the first, turning back to 296, the first 7, the first one begins, the first recital begins where is one of the main objectives. Mm-hmm. So that would be 1, and that down to the foot of the page are recitals 1 to 7. And then 21 and 22, my lady, are to be found at the foot of 297 and the top of 298. They are the last two recitals.
Thank you.
And then one reads Article 1 on 298. The purpose of this directive is to approximate the laws, regulations and administrative provisions of the member states relating to packages sold or offered for sale in the territory of the community. And what we have then in Article 5 is very different to what we had at the outset. We have suppliers, not third parties, so narrower in scope. In the context, and this is MS 300, in the context of now an included express reservation of the right of recovery against those suppliers. So we say, plainly envisaging suppliers being legal entities in the chain of contracts descending from the tour operator. Insofar as the Article 5.2 is concerned, we then have, of course, a move from strict liability to a number of defences, achieving a balance between facilitating the consumer's ability to recover by having a primary target in his own jurisdiction, the tour operator, and protecting the tour operator in circumstances where there is no fault, as defined, or the absence of fault as defined in 5.2. And in the course of the debate, and again I'll give your lordships the reference, but it's in the European debate, tab 45, MS 1188, part of that balance reflected the consideration that, of course, the wider the liabilities on the part of the tour operator, the more expensive holidays would become to consumers, which, of course, is part of striking the balance. Lords, I'm not going to respond beyond what is in our written case to the points made by the appellant in relation to one or two of the the Court of Justice of the European Union in both their written case and orally. Those are set out in our written case, paragraphs 124 to 130, MS 141 to 143. So, my lords, against that background, may I turn then to issue 1A? And we do say, picking up on my Lord Kerr's point, that there is no express term to the effect which is required in this case. The only reference in the contract, be it 2.2 or 5.10, is respectively services forming part of the holiday or holiday arrangements, very broad notions, admittedly. Clearly, no express reference to any of the sort of services which might give rise to a breach in this case. And even though Mr. Weir puts his case in terms of it's a construction of an express provision in the contract, as part of those submissions, he invites you to read in quite a long phrase as to the extent of that liability. And he also invites you to find that the scope of what has been agreed is not in fact determined at the time of making of the contract. It will be defined by whatever is provided at the hotel by whomsoever subsequent to making of the contract. And, my lords, I say that simply is not permissible at law. At law, one has to construe the terms of the contract at the time that the contract was made, and that cannot have been the reasonable intention of either party. Lords, may I turn to M&S and Paribas? That's volume 2, tab 27, and starting at 842. And may I start, please, with the leading judgment of Lord Neuberger, with whom Lord Sumption and Lord Hodge agreed, which starts at 850. And at 852 is the section which begins implied terms in contract, and also contains his observations on construing express terms as well. At paragraphs 18 to 19, 18 on page 853, he cites the well-known list of conditions stemming from the case of BP Refinery for Westernport and the judgment of Lord Simon. Namely, terms must be reasonable and equitable, necessary to give business efficacy, so that no term will be implied if the contract is effective without it. So obvious it goes without saying, otherwise the officious bystander test, and must be capable of clear expression. Fifth does not apply in this particular case. My lords, on the next page, at paragraph 21, Lord Neuberger, whilst not challenging the validity of that statement which he endorses, adds 6 comments of his own, which in a sense qualify it, and I'll invite your lordships to read those. They go from, this is paragraph 21, which stretches over the page to the bottom of that paragraph. And then, my lords, he turns to the question of express terms versus implied terms later in his judgment. At 24, sorry, no, not 24, my lords, just a moment, 26 to 28, which begin on 856. I accept that both construing the words which the parties have used in their contract and implying the terms into the contract involve determining the scope and meaning of the contract. However, Lord Hoffman's analysis in the Belize Telecom case could obscure the fact that construing words used and implying additional words are different processes governed by different rules. Of course, it's fair to say that the factors taken into account on an issue of construction, namely the words used in the contract, the surrounding circumstances known to both parties at the time of the contract, commercial common sense, and the reasonable reader or reasonable parties, are also to be taken into account on an issue of implication. However, that does not mean that the exercise of implication should properly be classified as part of the exercise of interpretation, let alone should it be carried out at the same time as interpretation. Now, other of their lordships also touched upon this issue. Lord Carnworth, at paragraph 68, this is at MS 867 to 868, and he's just cited a passage from Lord Neuberger that's in the Belize Telecom case, I believe. And at paragraph 67 in the second sentence, as I read it, the key points come down to 3. 1, although the implication of terms is one aspect of the concept of interpretation, it should be treated as separate and distinct from the more general process of interpretation. then I won't read the rest of that paragraph. I'll leave your lordships to read that. But then turning to 68 on the next page, the first point, i.e. the one I've just read, is an interesting debating point, but to my mind of little practical significance. It is not a point addressed by the parties before us, understandably if they regarded it as I would, as settled, if not by the Belize judgment itself, then by the authorities relied on by Lord Hoffman. Lord Neuberger, paragraph 28, prefers a sequential approach, first interpretation, then implication. However, as he accepts, paragraph 26, both processes are parts of the exercise of determining the scope and meaning of the contract. And so, and then at 69, he goes on to observe that in either case, the object, third line, remains to discover what the parties have agreed. And Lord Clark at paragraph 71, no, not 71, 76, also acknowledged the difference in that paragraph, but then goes on to say, however, like Lord Neuberger, I accept that both construing the words which the parties have used and two implying terms involve determining the scope and meaning of the contract. And the considerations that I've taken your lordships to are very similar, if not identical, as I accept they are not. So against that background, what did the parties agree? Lords, what the appellant has to show is that effectively what the tour operator, Kuoni, agreed to is some sort of term by which we were under a contractual obligation to provide guiding services at all times of the night and day by any members of staff at the hotel. Nothing less would suffice, because the circumstances of this case were a criminal assault at dead of night by an electrician, not customer-facing staff. Now, of interest, but I'm not going to take your lordships through it, it is set out in our written case at paragraphs 11 to 13, MS 108 to 109, is that over the course of this litigation, the terms for which the appellant contends have varied quite significantly, making it more difficult to see how it is capable of clear and expression. The terms now advanced in this court are new again. What it is said is that, first of all, the services weren't in fact fixed at the time the contract was made. They could be determined ex post facto during the holiday. I submit that is simply not right in law. Secondly, they are widely drafted. At one stage, it's the second point in a list of three, the relevant encapsulating term was said to be, we were under an obligation to provide assistance by any staff with ordinary matters affecting them at the hotel as part of their holiday experience. Add to that, by whomsoever. Now, on the one hand, Mr. Weir says you can discard rules of attribution altogether, not relevant. On the other hand, he says that anybody who providing any services at the hotel can, after the contract is made, self-authorise the acts he's then providing pursuant to the contract. My lords, I say that simply can't be right, and he says that to get round the difficulty he faces. And that difficulty stems from the acceptance by Lord Justice Longmore, the dissenting judgment in the Court of Appeal at paragraph 11 of his judgment MS 171. I'm not going to take your lordships to it, but effectively even he was at best unsure whether there was a contractual duty to guide at all. But he went on to find that even if there wasn't, N's subsequent offer to guide gave rise to a contractual obligation. Now, we say that is an error of law, with the greatest of respect to Lord Justice Longmore. If no such term can be said to be expressed or implied at the time the contract is made, one cannot then suddenly appear because N takes it upon himself to provide a service which we weren't originally obliged to provide. He cannot vary the contract after it was formed, and there's no consideration, and he has no authority to contract on our behalf.
What
So-
sort of services do you say the contract envisaged?
My Lord, in terms of the services that we are concerned with here, my primary submission is there's no obligation to provide any guiding services whatsoever. This is a common courtesy. It is not a contractual obligation. My secondary position is that at best, what can be said to be within the reasonable contemplation of reasonable parties at the time the contract was made was some form of assistance, certainly at the outset of the holiday, in familiarising the clients with the hotel where their room was and the grounds by customer-facing staff, not by any member of staff. By any member of staff raises all sorts of difficulties, which one only has to take the example which Mr. Stevens has identified in his skeleton argument, written case. Take the gardener in a foreign jurisdiction who won't even be able perhaps to communicate with the clients. How can he be expected to perform a contractual service of that kind?
Well, do I understand from that you are arguing that whatever the nature of the services, however they're defined, they're only owed by customer-facing staff?
At best, yes. If we were under a contractual obligation, as opposed to a consumer expectation, to guide clients around the hotel at any stage during the holiday, then at best it's customer-facing staff.
Well,
My
I'm
Lord's
not
had-
confining it to guiding services, because I think that's perhaps slightly distracting. But concentrating on the range of services that one would expect from an all-in 4-star holiday, I mean, surely can't be the case that the services could only be owed by customer-facing staff. One just has to imagine one doesn't always encounter chambermaids. One would rarely, I think, encounter kitchen staff, chefs, and so on. And they're not customer-facing. But would you not accept...
My Lord, I quite accept that, for example, Mr. Weir has taken cleaning services. I quite accept that there is an implied term that cleaning services will be provided, reasonable cleaning services will be provided for the accommodation.
So
That is one
it doesn't have to be customer-facing staff then?
Well, it depends on the obligation which we are promising to provide.
Well, the
Now-
various services which form part of the holiday you book presumably include getting fed in the restaurant and having your room cleaned.
Yes, my Lord, I accept that, and I would say that that is a customer-facing role. The people who are serving the food in the restaurant are in a customer-facing role.
Well, the people who are preparing it in the kitchen are not.
I accept that, but then one has, each of these cases is context specific. One then has to look at what service they are providing. Now, in this case, the service in question is said to be guiding around the hotel grounds and guiding around on the 9th day of the holiday. This is not at the start of the holiday, and it's never been the appellant's case that she didn't know where she was going. This is in the middle of the night by a man wearing overalls and found by the judge to be known to the appellant as a member of the maintenance staff. For this claim to succeed, learned friend has to persuade you that there was a contractual obligation by us for hotel staff, including maintenance staff, to guide clients around the hotel grounds at the middle of the night. And, my lord, I submit, with the greatest respect, that is utterly unrealistic.
Right. Well, we may have exhausted
My
that topic, haven't we?
My lord, may I distill that,
Yes.
having taken your lordship's two M&S into the tests? Why do I say that? I say that as a matter of law for these reasons. First, it is not necessary to give the contract business efficacy. Business efficacy on the passages I've taken your lordships to is not reasonableness. It is a stringent test. Can the contract work without such a term? My lords, yes. I say revealing is the fact that in 25 years of endless tour operator litigation since this regulation was passed, neither party, any party, has been able to land upon a case suggesting that such a term is implied into the contract or should be implied into the contract. Now, the reason for that comes back to the officious bystander test. Care must be taken in formulating the question, as Lord Neuberger identified. Suppose the parties at the time of contracting had asked, well, do you agree that Kuoni are obliged to provide guiding services throughout the hotel by all members of staff throughout the day and night? What would reasonable parties say to that? Do you agree that if you need to be taken to reception at 3 a.m, the hotel and Kuoni will be liable for breach of contract if no such service is available? What would reasonable parties say to that?
Well,
My submission is clear that they would not say that that was their expectation.
Suppose the client is taken ill or has a partner who's taken ill and needs to be guided in an emergency.
I quite accept that that is a different situation, because one could imply a term into a contract, my lady, that in circumstances of emergency, the parties agree to provide reasonable assistance. And one of those aspects of reasonable assistance would be getting the client to hospital as soon as possible or to a doctor or whatever. But that isn't this case. This case turns on Mr. Weir persuading you that N was providing a contractual service because we were contractually obliged to provide a guide at 3 a.m. by a member of the maintenance team. My lords, that is unreal, in my respectful submission.
Mr. Rawdon, what's wrong with an implied term to provide guidance when reasonably requested?
My lord, that would then become, that's obviously a vaguer term, but it would be more acceptable. That would be then a matter of interpretation when reasonably requested. Sorry, what was your lordship's phrase? When reasonably
requested.
Yes. On the facts of this case, that wouldn't suffice because guidance wasn't requested in this case on the findings by the judge. N offered to guide and then lured her into the engineering room. But then, in my submission, it is not reasonable to place a contractual obligation on the tour operator to provide unlimited guiding services throughout the holiday. Yes, there is an element of guiding which is a common courtesy and part of the ancillary nature, but to say that if say, a swimming pool attendant had been asked, can you take my daughter to reception? And the swimming pool attendant couldn't do it because he was under a duty to attend the swimming pool. Would that render us in breach of contract? No.
Wouldn't be reasonably requested, would it?
On your lordship's formulation, precisely. I accept that. So I quite accept that it is fact and context specific. There are ways and ways of formulating a term, but what I do say is that the appellant has been unable ever to formulate a term consistently, which is capable of clear expression and which suffices to catch the unusual circumstances of the assault in this case, namely maintenance man, 3 a.m. or thereabouts.
Would you accept, I know it's not pleaded in this case, that there could be an implied term that the guest shall reside in reasonable safety on the hotel?
My Lord, my Lady, that touches upon the question that you first posed to Mr. Weir this morning.
Mm-hmm.
And the answer to that case is to be found in the case of Hone, which Mr. Weir quite rightly referred you to in response. And that case is authority for the proposition that there is no warranty of safety. And that in the judgment of Lord Justice Longmore in that case, it's paragraphs 12 to 16, that is why one has to turn to the contract to determine what the services are, and once one has done that, it is accepted, and common ground in this case, that those services only have to be provided with reasonable skill and
That was
care.
the hypothesis of my question.
If my lady had, if the question had been, take reasonable care to see that the accommodation, i.e. the facilities, are kept reasonably safe for the use by clients, then I would accept that, my lady. But that won't suffice to attach liability to the tour operator in this case. Contrast that with the provisions I took you to in the Travo, where it was plainly envisaged in the legislative history that any injury sustained in the accommodation would pin us with liability. Rejected. My Lords, may I turn
Thank you.
to 1B, if a guiding term is to be implied. And for the sake of clarity, I make clear that whether one applies the express term construction, Lord Neuberger, or the implied terms approach, Lord Neuberger too, one gets to the same result. Applying common sense, reasonable expectations, reasonable parties, and it is reasonable parties with which this court is concerned. 1B, if your lordships are against me on that, and we were under a duty to provide such services. Here we say first, on the facts found by the trial judge, and this was the point that my Lord Hodge raised with Mr. Weir this morning, he was not providing, as a fact, a contractual service at all. That is paragraph 44, MS 192 of the judgment, and see also paragraph 48. So the appellant must therefore show that notwithstanding those findings of fact which are not challenged, N should be treated in law as if he were performing the contract. Here it is, my lords, that we say the appellant cannot do that for a number of reasons. First, luring is simply not guiding. Luring is simply part of the criminal enterprise. Nothing that N did was in pursuit of performing a contractual service. Now here, it is important to have regard to the appellant's own case at trial, because as we've suggested, given your lordships the reference, but I'm going to take you to them because it's important. The judge used words in his judgment like purporting to provide a service and ostensible service. These came from the appellant's case. And if I can take your lordships to the appellant's skeleton argument for trial, its core volume and it's in the appendix, and the skeleton argument starts at MS 202. But can we start at 204, please? At paragraph 6 on 204, halfway down the paragraph, she said she was going to reception, see the plan just below the bottom of arrow marked Bentota Ganga. He said there was a faster route and that she should follow him. In the course of the supposed short cut, they passed into an engineering room. Then turn to paragraph 37 on page 52, that's MS 215, halfway down the paragraph, the attacker volunteered to show her a shortcut. That was a service ostensibly provided to her, solely in her capacity as a guest. And then it goes on in the next sentence, the attack happened in the middle of, an inextricable part of, the purported performance by the attacker of precisely those services in hospitality which the claimant was entitled to expect. Then turn on, please, to paragraph 40, which begins at the bottom of 216, but it's 217 that we need, where it ends in the last two lines that the assailant was purporting to show the claimant a shortcut to reception and then committed a violent criminal assault. And lastly, next page, 218, paragraph 44, the instruction provides the basis for the function which ostensibly the assailant was performing. Now, Lords, it didn't just stop there, because on appeal to the Court of Appeal, the appellant made a further concession, and this is MS 246 at paragraph 31, skeleton argument for the Court of Appeal.
Sorry, what was the MS number again, please?
MS 246, my Lord.
Thank you very much.
Paragraph 31. Halfway down the paragraph, the sentence before the one I'd like your Lordship to look at, just to put it in context, it was not, nor could it ever sensibly have been the appellant's case that the sexual assault itself was an activity forming part of the holiday arrangements, nor was it the appellant's case that the luring of the appellant into the engineering room was the discharge of any contractual service. Now, my Lord, I quite agree, and I say that proves the respondent's case for it.
But in fairness, you have to read the next sentence as well. The pleader seems to be trying to draw a distinction between the luring and some prior performance of a service. You say there was none.
Yes. My Lord, that may be a fair point.
Well, I think you say, really, that there was never any question of performing a service at all. Right from the beginning, this man's plan was to perpetrate an assault.
I do.
And therefore, you can't, I would think your argument must run, you can't confer on the activity the mantle of guiding or providing a service or reacting to a request or anything like that, because right from the very start, his purpose was to perpetrate this assault on her. Those were the battle lines drawn, I think.
My Lord, they are, and I take the example of the concession made rightly by the claimant, that had N lain in wait in the bushes and jumped out offering no service at all, it's conceded by the appellant there's no breach, there's no liability. And I say that is telling. Effectively, what the appellant is saying is that what matters here is what the criminal chooses, how the criminal chooses to perform his criminal act. And in circumstances such as these, that is an unattractive argument, because it is more likely than not that a criminal such as N will try and use or abuse any position in order to gain an advantage over his victim. But what comes before, in a sense that also turns on point 1c, but what we say is that the proper question in each case is a question of attribution. Have N's acts to be construed as the provision of contractual services, and that depends on whether he had the authority to perform them such that he should be treated in law as performing them. And that brings us to the laws of attribution and Meridian Global. And may I invite your lordships at this stage to take up volume 2, tab 28, please. Now, my lords, I'm pushed for time, and I hope your lordships will forgive me if I don't take your lordship through the facts of this case. Rather, the judgment of Lord Hoffman, which was the only judgment of the court, starting at MS 877, please. At C, a third of the way down the page. It is a necessary part of corporate personality, and in this case we are dealing, whether hotel or tour operator, with corporate personality, that there should be rules by which acts are attributed to the company. These may be called the rules of attribution. And then dropping down to F, the primary rules are obviously not enough. He's discussed what those primary rules are, which are namely authority, which stems from the constitution of the company and the board of directors and the like, which obviously don't apply here. Primary rules of attribution are obviously not enough to enable a company to go out into the world and do business. Not every act on behalf of the company could be expected to be the subject of a resolution of the board or a unanimous decision of the shareholders. The company therefore builds upon the primary rules of attribution by using general rules which are equally available to natural persons, namely the principles of agency. It will appoint servants and agents whose acts, by a combination of general principles of agency and the company's primary rules of attribution, count as the acts of the company, and having done so, it will make itself subject to the general rules by which the liability for the acts of others can be attributed to natural persons, such as estoppel or ostensible authority in contract and vicarious liability in tort. And pausing there is an important distinction. Vicarious liability is a policy liability operating in tort. Agency is what applies with attribution in contract. We are operating in contract. That is why we say the rules of agency apply. He goes on, any statement about what a company has or has not done or cannot do is necessarily a reference to the rules of attribution, primary and general, as they apply to that company. My lords, although to save time, although it's not relevant to this part of the debate, may I take you to the parts of his judgment which touch upon the special rule which operates where you have a statutory, or it can operate where you have a statutory defence, and picking up at 507B to F, and this is on the following page, 878. B to F, at B, the company's primary rules, together with general rules and so forth, are usually sufficient. This will be the case when a rule of law, either expressly or by implication, excludes attribution on the basis of the general principles of agency or vicarious liability. But then dropping down to the middle of the next paragraph at E, but there will be many cases, is the passage I'd invite your lordships to pick up, in which neither of these solutions is satisfactory, in which the court considers that the law was intended to apply to companies, and that although it excludes ordinary vicarious liability, insistence on the primary rules of attribution would in practice defeat the intention, i.e. of the statute in this case. In such a case, the court must fashion a special rule of attribution for the particular substantive rule. This is always a matter of interpretation, given that it was intended to apply to a state of mind. Intended to apply to a company. How was it intended to apply? Whose act or knowledge was for this purpose intended to count? And one finds the answer to this question by applying the usual canons of interpretation. At he then goes on to discuss the case of Tesco supermarkets and Natras. Very quickly, this was a prosecution under the Trade Descriptions Act, where a store manager had kept out an advertisement that a certain product was available at discounted price, not realising that the packaging with the discounted price had been sold out, and so there was an offence. But the defence was offered, there was a defence offered under the Trade Descriptions Act if the shop owner could prove that the offence was caused by another person and he took all reasonable precautions and exercised all due diligence to avoid commission of the offence by anyone under his control. And it was held that the board, the company, had done that. The issue was who was the relevant shop owner for the purposes of the defence, whose acts would count. Because if it was the shop manager, no defence. If it was the board of directors, defence. And at 508 B to C, you'll see the question raised at B, whose precautions counted as those of the company. If it was the board, then the defence was made out. The House of Lords held that the precautions taken by the board were sufficient for the purposes of Section 24 to count as precautions taken by the company, and that the manager's negligence was not attributable to the company. And in that case, effectively, the structure of that is similar. The defence available is similar. The Act was there for consumer protection. Notwithstanding the consumer protection provision, the special rule was applied to find that the person who could avail itself, whose acts accounted for the purpose of the defence, was the board, not the shop manager, because the other result would have driven a cart and horses through the availability of the defence, which Parliament had intended to be available. I say exactly the same here, but I'll come on to develop that later. My Lords, you were also taken by Mr. Weir to Bilter and Nazir, and he took you to the judgment of Lord Hodge with Lord Toulson, but only to a part of it, namely the part on which he relies, which begins with a reference to photo productions and Securicorp. My Lords, may I just have a moment to find the reference? That begins at this is volume 2, tab 25, MS 817. And he took you to paragraphs 815 and 816. But in fact, what my Lord Hodge and Lord Toulson went on to say, that the question doesn't start and stop with photo productions. Photo productions actually just is authority for what in this case is a trite and accepted proposition by virtue of Regulation 15.1. Namely, if there's a breach of contract, it matters not who renders us in breach of that contract. But they went on to say that one had to look at Meridian Global, this is paragraphs 190, and relied upon Lord Hoffman, and at 191 said the relevance of the context in which the question is asked is not limited to Lord Hoffman's third category. The legal context, i.e. the nature and subject matter of the relevant rule and duty, is always relevant to that question, i.e. not just to the special rule, to all the rules. One looks at the context and the purpose. So it is important in my submission. That is an example of a case where the court started with photo productions, but actually, as we submit in this case, that's not enough. You have to go on and ask the questions, whose acts count to bind a legal entity? Now, we therefore say, applying rules of attribution, that, first of all, we say that the rules apply to performance of contracts just as they do to formation, and we've included authority to that effect in the bundle. I'm not going to take your lordships to it now. First of all, Professor Watts and Professor Reynolds in Boasted and Reynolds on agency. That is tab 40 MS 1100. And amongst the various cases they cite as authority for that proposition include the case of acute property developments, which is in your Lordship's bundle, and a case where the rules were applied in the context of performance, not formation of a contract. The reference for your Lordships is Volume 2, tab 19. I'm pushed for time. That case is dealt with in our written case, and I invite your Lordships to refer to that. So, on those principles and applying the rules of attribution and agency in contract, as to actual authority, N plainly had none, because he was simply acting dishonestly against the interests of the principal. And in such circumstances, he cannot have actual authority. The authority for that proposition is Lycett and Fulk, number 1, 1905, High Court of Australia, Volume 2, tab 38. And I'll take you very briefly to that, my lords, please, starting at MS 1069. First of all, this is the judgment of Chief Justice Griffiths, and it's the top paragraph on this page. The same principle applies here. If the agent has acted in his own interest, he does not bind his employer. But if there is an exception to this rule in the case of a person dealing bona fide with the agent without knowledge of the limitation of his authority, that is based upon the principle of estoppel. But there can be no estoppel if the person dealing with the agent knows the actual facts and knows that the agent is acting in his own interest. So that exclusion relates to apparent authority rather than actual authority. My lords, the other judgment is the judgment of Justice O'Connor, MS 1077. At the very start of his judgment, at the foot of that page, every authority conferred upon an agent, whether express or implied, must be taken to be subject to a condition that the authority is to be exercised honestly and on behalf of the principal. That is a condition precedent to the right of exercising it. And if that condition is not fulfilled, then there is no authority, and any act purporting to have been done under it, unless in dealing with innocent parties, is void. And again, that reference to unless in dealing with innocent parties is a reference to apparent authority, to which I'll turn now. So he has no actual authority. The appellant must prove that N has apparent authority. The appellant cannot discharge the burden of proof on that, and it's my case in any event that he had none. The leading authority as to the conditions which need to be satisfied is Freeman and Lockyer, and I'll take your lordships straight and only to, although we've referred to other passages in our written case, this is tab 21, volume 2, MS 715. It's the judgment of Lord Diplock, where he distills, having analysed the various cases on apparent authority, he distills them into 4 conditions, which he prefaces at the foot of 715, it must be shown, and then he lists them. Only the first 3 are relevant to this case, and they are, first, that a representation was made to the third party that the agent had authority, in this case to enter into a contract of kind, but equally to perform a service. 2, the representation was made by a person with actual authority to manage the business of the company, which we say N had no authority. 3, the third party was induced, and that's reliance. Those are the 3 conditions which the appellant has to satisfy. So what in this case were the representations. There was no representation made by the hotel via the house rules or the employment contract. Those were matters of which the third party, that's the claimant, the appellant, had no knowledge whatsoever. Second, the only representation can be his uniform. And that is the only one which...
Access to the premises, he was there late at night, wearing the uniform in the premises in a particular place where guests were likely to be found.
I accept access to the premises, but my lord, that wouldn't really take one beyond uniform. He was in his uniform, indicating, and it was accepted that she knew that he was a member of the maintenance staff. But I accept my lord's point. But he was there, but he was wearing overalls. He was plainly, as the judge found, non-customer facing staff. He was not the security guard. And here, too, it is relevant to bear in mind the appellant's case at trial. At trial, her case had been that she trusted him because he was a security guard. My lords, the references to the judgment are MS 189 and MS 190 to 191, and I invite your lordships to read paragraphs 30 and 31 and 36 to 38. He found that she knew him to be a member of the maintenance team, contrary to her case, and he found that she had embellished her case in order to bolster it. It follows that he found that her case that she trusted him because of who he was rejected as a fact. So, reliance, at the very least, cannot be proved. My lords, for those reasons, we say the case fails under 1B. N was not providing any contractual guiding service at any time, and he had no authority to do so, such that his conduct is not attributable to the hotel or the tour operator in law. I turn to 1C. My lords, in any event, an assault does not amount to a breach of duty. So here, if we are here because your lordships have found we were contractually obliged to provide the service which bit on the circumstances in question, and we breached that duty in the guiding. But the assault is a different thing altogether, and we draw a clear distinction between it, and that is what separates issues 1B and 1C. So even if we fail in 1A and 1B, we say the assault cannot be, and it's accepted by Mr. Weir, it cannot be a failure to guide. How can it be a breach of contract? It is not. It is a criminal act. And here we say the appellant's case is conceptually flawed. And here too, I pray and aid the example of the difference between jumping out of the bushes as the pretext to a rape as opposed to luring as the pretext to a rape. In one circumstance liable, in one not. We say no, not liable at all, whatever the pretext. It was all a criminal enterprise. My lord, the appellant relies here on Morris and Martin to show that a duty can be deliberately breached as well as negligently. But with respect, and my lords, I'm not going to take your lordships to it now, but I will give you the references, that somewhat misses the point. In Morris, there was a duty owed in respect of the very breach committed by the employee. This was a bailment case, and the bailee had delegated the care of the fur to the employee who stole it. The duty was to guard that fur from, amongst other things, theft. He committed it. And my lords, the interesting passage is in fact in Lord Justice Salmon's judgment at MS 928, 740F to 741C, he finds, I'm not going to take your lordships to it because I'm afraid I'm running out of time and I need to move on to the defence, but he finds that the defendant was liable because he employed the thief in order to look after the goods. He then goes on to distinguish with a case where the theft was by another of his employees who wasn't charged with that duty. And in that scenario, Lord Justice Salmon says he wouldn't be liable. The employer would not be liable. So whereas the appellant refers to this case as supporting the proposition that it matters not whether the service was provided carelessly or deliberately, we say this case first involves very different duties: bailment, which is effectively a warranty for safety of goods, and it is agreed in this case there is no warranty for safety at all in this case. Our case in contract, here we have a contract in which the hotel did not put N in place to look after the appellant. He was an electrician. N is akin to the exception identified by Lord Salmon, which drives him to say, in those circumstances, the master, the principal, would not be liable.
Well, could I just ask you about that? Because I'm not quite clear how this all fits in with Article 5. Article 5 says that the member state must take care must ensure that the organiser is liable to the consumer for the proper performance of the obligations arising under the contract. And it doesn't say anything about there being a defence because the breach occurred by somebody who was not authorised to deal with that particular matter. You're adding to the defences in this case, aren't you?
Article 5, my lady, if I...
This is the irreducible minimum, isn't it?
Yes, Article 5, but it can't be said, our submission is this, that it does not follow from that all acts by any agents of principals amount to the performance of contractual services.
Yes, it says the proper performance of the obligations. It doesn't say by the right employees. It simply says the proper performance of the obligations. Brackets, by whomsoever, arising from the contract. Otherwise, it would not protect the consumer because the employee might be acting totally outside authority.
My lady, I accept that. But one always needs, here we are looking at liability of a legal entity, and one always needs to look at the rules of attribution because not every act by whomsoever will amount to a contractual service. Well, Mr. Weir's concession identifies that point.
Well, with respect, we're dealing with a European Union instrument,
yes,
not with a domestic concept of attribution. And the wording of the section of the article is simply liability for the proper performance of the obligations arising from the contract. So why are we heading off to the common law and attribution and apparent authority? Surely we should simply apply the words of the article.
Well, in fact, my lady, under the defence, and I accept this is under the defence, not 15.1, right, the words attributable are actually used in the directive.
Yes, but that must be with an autonomous meaning. It cannot be just simply a common law concept.
Well, whether in any jurisdiction a legal entity cannot act except through agents. So the same problem is going to arise in any jurisdiction. And in each case, one has to ask oneself, is the act in question attributable to the company? I take my lady's point, but in my submission, we are dealing with the regulation. The liability is arising under the regulation. And the law of this land is that when we are looking at whether an act has been committed by a legal person, one is necessarily looking at the laws of attribution. And Well, my lady, if I may, I'll leave it there.
Is that not inconsistent with the objective of the directive of achieving a uniform system throughout the European Union?
My Lord,
Vary in each
that-
case, depending on national rules of
that is always the case, my Lord. My Lord, there will be the regulations or the equivalent in other member states, not the directive, will always be interpreted in a number of different member states. And where there is an issue, obviously then possibly with reference to the European Court. But in an ideal world, there would never be any differences between any of the national laws. In that regard, may I make one last point, which is that I've taken your lordships to the travaux préparatoires, and I say they are an aid to interpreting what the directive in Article 5 says. And I submit that the clear intention was not to impose a liability on a tour operator for unforeseeable criminal acts of someone like N. I've made my submissions on the travaux, but I say that supports the construction for which I contend under Article 5.1 and Regulation 15.1. My Lords, may I turn to the defence? Our alternative case, and we get here, if I've failed to persuade you on all of points 1A, 1B and 1C, is that if a liability arises, it is nonetheless an excluded liability in the sense that we can avail ourselves of the defence in Regulation 15.2c2, Clause 510b of the contract. Our case in outline here is this. On a proper construction, both of the contract and the regulation, suppliers, and for this purpose one can ignore the fact, as Mr. Weir has pointed to, that the contract says our suppliers, which is a word not used in the directive, because I've conceded in the written case that it was always intended that the contract incorporate the scope of the liability under 15.1. But a supplier, we submit, is not, we accept, limited to those with whom we are directly in contract. It does extend to those with whom we are indirectly in contract, provided that they are contracts for the supply of services under the holiday contract, so those in the contractual chain. But it does not, we submit, include all the individual servants or agents of those suppliers in the contractual chain. That construction, we submit, is consistent with the legislative history to which I've taken your lordships already, and narrowing down from third parties down to suppliers, and a specific inclusion late as to the right of recovery against those suppliers, which must envisage a chain of contracts and recovery thereunder.
Does it include all of the servants and agents who are in fact supplying services?
My Lord, we say that it includes, by a process of attribution, it will include, but not because they are suppliers, but because their acts are acts which count as the supplier's acts. So if they are acting within the scope of their authority and performing a contractual service promised under the contract, then yes, but not because they are suppliers, but because their acts are acts done on behalf of the supplier.
Right. But so long as they're supplying services, then they come within the category.
So long as they are supplying the services and with authority, yes. So in my lady's point about the person who is moonlighting I say that wouldn't count. That person cannot self-authorise the performance of a holiday contract service by moonlighting and saying he or she is doing it on the part of the tour operator or the hotel.
Mr. Audland, presumably the word supplier or suppliers must have the same meaning in the contract, in the regulations, and in the directive.
Yes,
So it's going to have a consistent, autonomous community meaning.
yes.
Now, your submission is that it should be read subject to a limitation. You say it extends to those with whom the service provider is in direct contact by contract, provided that it was, in each case, it's a contract for the provision of services in the chain and doesn't extend to contracts of employment. That was the note.
No, it does not extend to contracts of employment.
That was the note I made of your submission
Yes,
a moment ago.
yeah.
Now, that's a question of EU law, isn't it?
Ultimately, it is a question of EU law, but I say it is clear from the history to which I've taken your lordships what the intention of the supplier was.
That would be my next question.
Indeed.
Is it accurate?
And that is the point, that it started out, the original proposal was for third parties. Third parties could be anybody, and that is effectively Mr. Weir's case. That was narrowed down to suppliers with an inclusion about recovery against those suppliers. Now, although he hasn't developed it in oral submissions today, part of the claimant's case is, oh, well, it doesn't matter, this is all about consumer protection, make the tour operator liable, they can rely on their indemnity. How can we rely on an indemnity in this case? The indemnity, I'll take your lordships to it in a moment, if necessary, but it doesn't cover criminal acts which were unforeseeable by the hotel.
Well, if
At this point, I'm interested in the basis on which Lord Justice Longmore dissented on the second point.
On which point, my lord? Sorry.
On this second issue of the defence,
Yes.
he dissented on that issue on the basis
I didn't hear you.
on the basis of the meaning of the word supplier.
Yes, he did.
So there was a disagreement in the Court of Appeal as to the meaning of supplier.
There was indeed. But, my lord, in essence, what I say, if supplier covers N and anyone like N, this defence is unavailable in circumstances where it was meant to be available. Here we have a case where it is agreed by all there is no negligence, no fault on the part of either the tour operator or the hotel. Now, what purpose, other than to give a tour operator a defence, in such circumstances does C2 have? And I say it was there precisely to enable, and I refer back to the debates and the history in which fault became included within the scope of both the liability and the defences to that fault, say it was precisely to cover circumstances such as this, because fault is a core element of liability under 15.2. And here we have a case. So turning it around, if N is the supplier, then there is an almost unlimited liability, and the tour operator will never have a defence in circumstances where there's no fault. Let's say, for example, in the horrific recent events in Sri Lanka, the hotel bombings, they went off in hotels. Let's say one of those bombs had been deposited by an employee of the hotel in an operation of subterfuge. The consequence would be we would have no defence. That would always have been foreseeable and forestallable by the criminal. Can that have been the intention of the council? I submit not.
Yes, I note in 15.2b, unforeseeable and unavoidable failures by a third party unconnected with the provision of services gives rise to a defence.
It does, but of course, and that wouldn't be the scenario which I've just indicated to your lordships.
No, but what you're saying is that C2 is a provision which would cover such circumstances where the person was someone connected with the supplying of the services.
Precisely. And what Mr. Weir says is that that person would be any person who offered in any way to assist the client for the purposes of the holiday, ex post facto, once they'd arrived on holiday. So this is an unlimited liability for which we would have no defence. That cannot have been the intention of this legislation, my lords. My lords, I do pray in aid a special rule, but I say I don't need to. It's if necessary. I say that the construction for which we contend is clear from the Travo, and any other construction would simply drive a cart and horses through the defence and render it nugatory in effect. But if I need to, I do say a special rule should be construed for the facts and context of this particular case, because I say this is just the sort of case for which this defence was intended to bite. No fault identified on either the part of the tour operator or the hotel, the only fault on the part of a criminal. And that is done. I've taken your lordships to the passages, and that is a question of construction in each case on the principles of Lord Hoffman. And on the facts of this case, I say both the directive and the regulation in particular on which we rely provide for a defence in one of two ways. First, the supplier cannot be N. The supplier has to be the hotel. Second, because N's acts cannot and should not be attributed to the hotel. And that conclusion, one is driven to that conclusion for the same reason as the House of Lords was driven to the conclusion in Tesco and Natras, namely, any other result would simply render the defence which was enacted worthless. My lords, can I turn very briefly to the question of the Unfair Contract Terms Act and section, well, perhaps I can just ask your lordships to turn that up. It is tab 12, no, that's the regulations. The Act is...
It's 11. Tab 11.
Thank you. 11. Thank you. The first point, so the starting point is section 2.1, my lords, on 465, MS 465. And in a sense, it's an obvious point. The provision is, a person cannot, by reference to any contract term, exclude or restrict his liability for death or personal injury resulting from negligence. That's not what I'm seeking to do. It is agreed that there is no negligence on our part. The reference to 29, section 29, which is 479 to 480, my lords, this section is entitled Saving for Other Relevant Legislation.
Forgive me, before you move on to 29.
Certainly.
Mr. Weir does rely on 11A, the definition of negligence, as including any obligation arising from implied terms to take reasonable care.
But in this case, I, the tour operator, am not at fault. This is in the context, this Act comes into the context of 15.2, not 15.1. So it's whether 15.2, I can rely on 15.2. 15.2 gives me a defence where there is no fault. It is accepted that my client, Kuoni, is not at fault, is not negligent. So I say, notwithstanding the definition of negligence within the Act, this does not disentitle me from relying on the defence. The subsidiary points which are made in our written case, but which I'll just respond to Mr. Weir on, which is section 29. First of all, section 29(1)A, that's 479. And for your Lordship's reference, enactment is defined under 29(3) and includes all subordinate legislation. So I say includes the regulations. Nothing in this Act removes or restricts the effect or prevents reliance on any contractual provision which is authorised or required by the express terms or necessary implication of an enactment. That is precisely this case. It has been agreed all along that the intention of Clause 510 has been to carry into effect Regulations 15.1 and 15.2. I have conceded that if and to the extent that the scope of 15 is wider by the reference of the words "our supplier," then that is of no effect. That's Regulation 15.5. But nothing in here, everything in here entitles me to rely on a defence which is permitted by the enactment. That is Regulation 15. The second provision also applies, and to the extent that Mr. Weir now says, well, he's only pursuing his claim in contract, that is simply not the case. He's always pursued the claim in contract and the regulation, even in the written case, and in any event, I have always relied on Regulation 15.2 as a defence. I'm entitled to rely on a statutory defence. He accepts it's a statutory defence. This Act allows me to rely on it. Insofar as I need to, but I say that I don't, B bites in this way. The compliance, that the directive was made under the Treaty of Rome. It's a consumer protection directive. There are references to that in the debates. The regulation is to carry the directive into effect. So it is with a view to compliance with our obligations under the Treaty of Rome. And in that way, I'm also entitled to rely on the defence and say, as I do, that ACTA is nothing to the point. My Lords, Mr. Weir touched upon McNichol and force majeure. I say that I simply refer your Lordships to our written case on that. We've dealt with that at the end of the written case. We are not dealing with force majeure in this case. That is a completely different defence. And McNichol, interesting though it is, takes this case no further at all. Lords, may I just have a moment? Yes, there's one other point which I wish to respond. I think Mr. Weir was saying that our case, if he'd understood it correctly, was that all criminal acts can't be a breach of duty. We don't say that. Say, for example, a security guard at the hotel stole something from a client. There is a man whose very duty is like the bailee or the sub-bailee in Morris. We say that we would be liable for such a criminal act and we would have no defence to that because his acts will always be attributable to the company, his employer, because he is performing the very duty that he was authorised to do and he's breached that very duty. That is very different to this case. So we don't say, for the avoidance of doubt, that no criminal acts will be caught.
Yes.
On force majeure, wasn't the point being put rather more widely in saying, look at the method of reasoning in McNichol they did not allow force majeure to be raised, and likewise here it would be said that the hotel could not say that the event was unforeseeable, and one should take into account the fact they could always have sought insurance against the fact of the non-performance or the unlawful acts of their...
My lady, I accept. Can I deal with those 2 points in turn? First, I say the legislative history trumps an authority which is on a different defence. The legislative history which I've taken your lordships through addresses this very defence. And it also addresses whether or not this is intended to cover liability for criminal acts. Second,
Insurance.
Insurance and indemnities, as we say in our written case, are not aids to construing a contract. And the absence of insurance in this case, my lady, it's the indemnity is in the accommodation contract at clause 12. It's absolutely standard. It doesn't allow us an indemnity in circumstances where the hotel is, as is admitted here, not at fault.
No, all I think the court was saying in McNichol was it's foreseeable. A commercial enterprise can factor into its risks the fact there may be unlawful acts by employees, and no doubt by employees.
Can be insured.
And you can buy insurance against that, whereas the consumer is not in that position.
My lady will recall that as part of the legislative history, Article 7 was focused upon insurance. And initially there was a provision that all tour operators had to avail themselves, this is 7.1 in the proposal, they had to insure themselves against any insurable liabilities. That was removed from the final Article 7. The final Article 7 is just about bonds in respect of insolvency.
Well, I'm afraid you're past your time.
My Lord, I'm more than conscious of that, and I apologise to Mr. Stevens.
Well, not at all. My Lord, I have discussed what I'm about to suggest with my learned friends and make a suggestion in the hope that it might be of assistance. Conscious of the time, the fact that Mr. Weir wants his 20 minutes to reply, I could put my submissions in writing relatively briefly. So in other words, Mr. Audlin would finish, Mr. Weir would respond, I would put those in writing, and Mr. Weir would be able to respond briefly in writing to them, if that would help. Because I'm going to be quite pushed as well.
Yes, it's going to be. Well, it'll be a shame not to hear from you, Mr. Stevens, but I think that seems to be a sensible solution. But before I call on Mr. Weir, Miss Ross, do you follow?
I thought that Mr. Stevens was offering more time.
He was, but may I just consult with my learned juniors as to whether I need to address your lordships at any greater length? Thank you for giving me a moment, my lord. I'm happy to say, although Mr. Stevens, I'm very grateful to Mr. Stevens for the kind offer. Unless your lordships have any further questions for me, I don't need further time. I obviously rely on my written case as well. I invite you, for the reasons given, to dismiss this appeal.
Right, thank you very much, Mr. Audlin. Now at last, Miss Ross, do you follow? No, right. Okay, then Mr. Weir.
Please, Your Lordship, can I go through just in the order in which I'm, particular order, responding to the issues that have been raised. Can I start with the travaux préparatoires and the fact that the respondent seeks to draw helpful inferences to it from the fact that liability was initially to attach to a third party and then drafted so as to cover the performance of the contract even by another supplier of services. A supplier of services is any relevant third party. Instead of simply saying third party, this is the focus that needs to take place on these words. It's not supplier. And that's how the Court of Appeal majority approached it. One can understand if you say my supplier, you might be referencing the person with whom I'm in a promissory or contractual position. But it's not. The emphasis on the service, because we are dealing here with a breach of duty that results as a result of the failure to perform or improper performance of a service. And the regulation provides that there will be liability attaching to the tour operator by whomsoever the service is provided, in other words, by another supplier of services. That's any third party providing the relevant holiday service. It simply doesn't bear the weight that the respondent wishes to attach to it. And Lord Lloyd-Jones has already made the observation in relation to where's the limitation, that there has to be a contractual chain. There is no such limitation in the language before we even come to it's a derogation. And so it needs to be construed restrictively, and the obligation to construe favourably to a consumer. There's just nothing in the language of supplier of services, when you recognise it's all about the service, that says that's a supplier of services who has to be in a direct chain of contract or obligations or whatever. I've given the example of a gratuitous provider of relevant services. The respondent also seeks to attach weight to the proposed amendment which would have attached liability for what I would call unrelated criminal activity on holiday. That was the authorities 3, tab 44, 1154 provision, which came in and went. So that was 44, 1154. We see in the draft amendment number 24 and amendment number 25. That was a form of, or equivalent to, what we have in this country as CICA liability, Criminal Injuries Compensation Authority liability. That's to say, you've been on holiday, you've sustained an unrelated criminal injury, and there should be some form of insurance or compensation. And perhaps not surprisingly, that was rejected as being too broad and not going to the heart of what the package directive was intended to achieve. But it cannot be drawn or inferred from the introduction of a proposed amendment, which was then withdrawn, in relation to unrelated criminal activity, that somehow Article 5 of the directive, and hence Regulation 15 of the regulations, has to be interpreted restrictively so as to keep out criminal activity. Regulation 15, Article 5 are concerned with breach of the promises, breach of contract, not with unrelated criminal activity. And that error persists because even right at the end it's put against us in a flourish that if an employee had been one of the terrorists in Sri Lanka, how could they protect themselves against that? Where is the performance of the holiday service if an employee has reasons to his own end chosen to load himself up with a bomb and set it off in a hotel? This is concerned with the failure to perform or improper performance of holiday services under the contract. And so for those purposes, that individual would be unconnected with the holiday services, a third party unconnected with the holiday services. That is not what Article 5 was protecting consumers against. The issue of the indemnity has been raised, the indemnity would on its face comfortably cover this case, because this is a case for breach of contract. And this goes back to what, as my Lord Kerr, lies as a dividing line between the parties, whether one seeks to construe the activities of N with a criminal hat on, which would be relevant for criminal prosecution purposes, and say, but here was a criminal, or whether one seeks to put on the hat that says, is this a breach of contract? Because criminal conduct can lead to the respondent being in breach of contract. And the indemnity is, again, very, very hard to read, but it's deep within the hotel respondent contract, and it's page MS 285. 286, I'm sorry, 12.5. So it's left-hand column at 286. Extremely difficult to identify, but it is there. 12.5, which is about a third of the way down. And it actually says, if the supplier fails to fulfill any of its obligations to Kuoni and or to clients as set out in the agreement, the supplier shall fully indemnify Kuoni against and hold Kuoni harmless, etc. That's what it says.
Certainly for my part, it would be helpful if there are to be written submissions, if a transcribed copy of this could be provided.
Very, very simple, yes. I think there may have been a debate as to whether it was to appear in the statement of facts and issues, and so it didn't, and then we should have put it into our case, and we didn't. We'll remedy that error. So once one recognises that we're concerned here with a failure to perform a relevant service, and we see there the provision within the terms of that contract, which was to provide a range of services for the benefit of the customer, if the court is with the appellant's case vis-à-vis the breach of contract, then the indemnity would surely be triggered. In any event, and this is set out at some length in our case, it's no part of our case that we need to establish that without doubt the indemnity bites. We start with the ordinary approach under English common law. And the ordinary approach under English common law is one which was adopted or recognised a long time ago in a case called Young and Martins, which is in volume 2. It's House of Lords. It starts at 1009, and we see at 1021 in the judgment of Lord Reed between E and F. This was a contract for labour and a building contract. We see, and if that seller had in turn bought from someone else, there will again be liability. This was the pre-photo securical point about breach of contract by the person making the promise. And then continues, so that there will be a chain of liability for the employer who suffers the damage back to the author of the defect. Of course, the chain may be broken, because the contractor or an earlier buyer may have agreed to enter into a contract under which his supplier excluded or limited his ordinary liability under the Sale of Goods Act. But in general, that has nothing to do with the employer and shouldn't deprive him of his remedy. And you'll see the same point at 1025 at the top, per Lord Pierce, A, and at 1030 in judgment of Lord Upjohn at C, which Lord Upjohn, this is 1030 at C, says the practical business effect and just solution to this type of breach of contract is that each vendor or contractor of labour and materials should warrant his supply of materials against patent and latent defects, So by the well-known chain of third parties procedures, the ultimate culprit, the manufacturer, may be made liable for his defective manufacture. And such an approach has been echoed in Regulation 15.1, because one goes back to Regulation 15 at Authorities Bundle 1, Tab 9, page 434. That's 434. The court will see Regulation 15.1 provides the liability, which we've rehearsed, and then concludes, but this shall not affect any remedy or right of action which that other party, that's the tour operator, may have against those other suppliers of services. It's recognising the remedy, the right and remedy for the customer lies with the tour operator. The tour operator then turns its face, and it could sue in tort if it wanted to, or non-contractual obligation, maybe under foreign law. Or it can sue in contract and seek to protect itself with an indemnity. It can seek to obtain insurance in the ordinary way. These are all points that are recognised. They're recognised in the case of Wood, in which the same as Sir Brian Leveson described it, floodgates argument was raised. It's very shortly dealt with. It's Authority Bundle 2, tab 35, page 1008. This was liability for food, because food's goods and they have to be of satisfactory quality. The complaint made, a tour operator, how has a tour operator suffered this when it has not been at fault? 1008, my lord. We're in the judgment of the President of the Queen's Bench Division, paragraph 34. That was the argument, and you see it, 34. Neither do I accept the floodgates argument which Mr. Aldershot's counsel for the tour operator advanced. I agree it's always difficult, indeed very difficult, to prove an illness as a consequence of food, etc. The fact is, however, the judge found as facts that these have been proved in this case, and no appeals have been pursued against those findings. In any event, while I recognise that tour operators will complain they're being held liable for events outside their control, there are many ways in which protection from exposure in this area can be achieved. And the court was drawn to the passage in Young and Martin's case.
That's critical to your case, as I've understood it, that this is a supply of services. What is said against you is this is self-evidently not a supply of services. There's nothing really to distinguish N jumping out from behind a rock or a bush and attacking the appellant, and his engaging in an elaborate stratagem which has that purpose right from the very beginning.
My lord, yes. First, it's not known what his purpose was and whether it was from the beginning. There's no finding in relation to N's purpose from the offset. The moment it says he lured her into the engineering room. That's what the judge says. He doesn't say lured her off the path. It says lured her into the engineering room. We don't know what his motive was or when his ill motive commenced. The first submission I've already made is his motive is irrelevant. What the court must avoid at all stages doing is eliding the promise with the breach. What we have here, and this was a submission I made right at the end of my section 4, and I remember at the time a slight quizzical facial expressions as I made it, as if the point had not carried any weight with the court.
Oh, you should never make that assumption. Maybe
I do hope it had, my lord.
That we were stunned by the magnificence.
Faults of advocacy at all stages only, which I seek to make good at this stage. But I had said at the end that N had offered to provide a holiday service. That's a fact. Once one has to accept earlier parts, but if we're well at this point of the stage-wise process, it offered a holiday service and the appellant had accepted. And because of that, there is now a promise to deliver that service. And if that service was not delivered with reasonable care and skill, it would render the respondent in breach of duty. It was not delivered with reasonable care and skill. What is happening is, as if to say, taking the coach example that I've given before. Well, I know he's driving the coach right up until the point when he decides to use the coach as a weapon because he's engaging in road rage. He's not driving the coach now, he's using it as a weapon. He has a malign, evil, criminal purpose in his mind. So what? So what? Doesn't matter. There was a promise to drive carefully. He didn't drive it carefully. You don't go into the motive of the tort, that tortfeasor, or call the person what you will, the culprit, the criminal. It doesn't matter. You ask, was a hotel service to be provided, and was it then provided carefully? If it wasn't provided carefully, it matters not whether it's provided to a criminal degree of severity or merely carelessly. And my Lord, I hope that is an answer. At one point, it was then further put, and this was in relation to the Unfair Contract Terms Act. Well, but N's not at fault. N didn't promise this. The tour operator didn't promise this, so we don't even get into Section 1.1 of the Unfair Contract Terms Act. We'll go right back to the beginning in the Statement of Facts and Issues, which is it's MS 68, paragraph 7. This is agreed. Pursuant to Section 13 of the Supply of Goods and Services Act, the respondent was required to carry out the service promised under the holiday contract with reasonable care and skill. So if it's not, the respondent is at fault it's a fault-based breach of contract. It's no more complicated than that. And then what happens is the respondent saying, well, I know there's a breach, but it's not by me. But that's Photo Securico and Wong Mi Wan. We've been over that ground. It doesn't matter. You're in breach of contract because through others, you have failed to deliver the service with reasonable care and skill, which is fault by the respondent. It's fault-based breach of duty.
It might be better, perhaps, to regard it through the fault of others. The service has not been provided, rather than focusing on who is responsible. I mean, your point is that the tour operator takes on a responsibility, contractual responsibility, to supply the services. If the services is not supplied, then prima facie there is liability.
Well, it's exactly so. It's why a short while earlier I've sought to emphasise it's not supplier, it's supplier of services. It's all about the services. That's what it is under the contract. That's what it is agreed. It has to be carried out with reasonable care and skill. It's the services. And the service here was the service of guiding. It wasn't, whether it wasn't from the off or not, is not to the point, and there's no finding of fact on that. It doesn't matter. That is materially different, critically different from the leaping out of the bushes, simply dragging somebody out of the bushes, putting them back in the bushes, and then assaulting them. That is a very different case. It's also said, well, the 1990 directive key objective is harmonisation. Can I, for these purposes, go back to the CJEU case law? And I start again with the Leitner opinion of the Advocate General at paragraph 26. That was 116.588. Para 26 at 588. This is after the Council directive is fully formed, in which the Advocate General says, in the event of any doubt, the provisions of the directive in question must be interpreted in the manner most favourable to the person to whom they're intended to protect, namely the consumer of the tourism service. That may be inferred not only from the systematic analysis of the text and aims of the directive, but also the fact it's adopted pursuant to Article 100A para 3, of which requires that harmonisation measures in respect of consumer protection should be based on a high level of protection. The Rechberger case, which I haven't gone to previously, is in tab 18, and starting with the Advocate General in that case, at page 630, paragraph 17, so I'm 630.
In Leitner, did the court itself say anything about the interpretation?
Yes, it does, my lord. It does in the Blowell case that I took the court to briefly.
Yes, because one can attach perhaps more weight to what the court says rather than the opinions.
My lord, that's absolutely. May I just at least highlight, before going on to the court, may I at least highlight paragraph 17. You'll see left-hand column, informed by the general principle in case of doubt, its provisions must be interpreted so far as possible in favour of the party to whom protection is intended to be given, in this case to consumer of tourist services. And then you'll see set out in the remainder of the paragraph, including right-hand column high up, it is to be inferred the main concern, so about 8 lines down, right-hand column, behind the harmonisation initiative is to promote effective protection of a high level of consumer rights, in reference again to Article 100A at the bottom and going over the page. The court at paragraph 5, which is at page 648, says Articles 3 to 6 of the directive contain provisions designed to protect the consumer against certain risks in package travel, namely the risks relating to misleading information in descriptive matters concerning the package, the arrangement for payment of the package price, and the spreading of responsibilities between the organiser, retailer, and the various providers of the service comprising the package. Dillon Coffer, which I said we had in the bundle, and we do, paragraph 39 at page 567, there's para 39, right at the bottom of 567. The recitals in the preamble to the directive repeatedly refer to the purpose of protecting consumers. Secondly, the fact that the directive is intended to assure other objectives cannot preclude its provisions from also having the aim of protecting consumers. And then again reference the Article 100A brackets 3 of the treaty, take as a base a high level of protection. So, my lord, the overall effect of that which the court held is consistent with that which was recommended or given by way of opinion by the Advocate Generals. I've taken you to para 24 of Lodel at page 498.
So consumer protection trumps.
Consumer protection trumps, my lady, exactly. My lord, at one point it was put that whether express or implied, they're very similar, and in the next breath, well, it's not. It has to be necessary, and that's a stringent test. Well, it doesn't have to be necessary. It isn't a stringent test. It applies when construing the express terms. And I know there was an observation from my Lord Lloyd Jones on the basis of what could be implied, but I would invite the court not to feel the necessity to imply a term, but to treat this as the construction or interpretation of the various services term in the contract, which per the statement of facts and issues, it is common ground, which we started with being common ground, have to be provided by the respondent with reasonable care and skill. And it's provided with reasonable care and skill, again, when an effort is made to poo-poo the appellant's case and to sort of embarrass it on the basis, should a gardener be expected to do this and so forth, it's exercising reasonable care and skill. So the gardener doesn't necessarily have to provide the guiding service. I gave that example already. It may be, and then we've got the customer-facing argument, it may be that someone on reception says to a non-customer-facing employee, will you please show these people to their room? Now, We don't go back and say, but that's not what I would have expected at the time I entered into the contract. That's part of, these are the services which are provided at the time. They may have a shortage of staff. It may just be something a reception staff chooses to do. It doesn't matter. You have to start looking at it from the perspective of the customer. The customer is now being provided with a service. And that's a service which the customer would understand is being provided as an ordinary incident ancillary to their accommodation. So it doesn't matter by whom it's provided at all in that sense. It has though to be a holiday service. And so if one customer directs another customer, that's not a holiday service. That's like the terrorist or the employee who's chosen to be a terrorist with no regard to anything to do with the holiday service. That's someone, the language of Regulation 15, a third party unconnected with the provision of services. That's something quite different. But the way in which the case has been put before this court, again, criticised on the basis it doesn't in any way mirror the way it was put before the Court of Appeal, but it does in our skeleton argument for the Court of Appeal at MS 244, paragraph 22, which I invite the court quickly to turn up, if you kindly will. Never understood the case at that point to be about implied terms in argument. That's a new argument, but so we don't go around saying express terms other than referencing the holiday arrangements, which the Court of Appeal majority itself chose to construe. But in the middle of 22, you see, they also included, as an integral part of services to provide on a holiday to a hotel of this quality, assistance from hotel staff with ordinary matters affecting guests at the hotel as part of their holiday experience. And if we're in the business of yet further examples, what if the customer gets lost in the hotel and finds himself, for instance, deep in the kitchens? An example given to me in practice from a colleague in Chambers on a holiday and finding himself in just that position, and then asks the person in the kitchen to help to get out. If the person in the kitchen says, I don't understand, or words to that effect, so be it, that they may not have breached the holiday service, but if they say understand fully what's being asked, and they direct the person into what we in personal injury terms would call a danger and a trap, so down an unlit stairwell so they topple down into the cellar and hurt themselves, they've provided a service for which the tour operator would be liable. So there is no problem, no insurmountable difficulty with this. This is no different in principle from the cleaning service which is being provided, which point is still avoided assiduously by the respondent in writing and orally as to whether they accept there would be liability in that situation or not. Assiduously avoided, because they can see where it goes once they recognise that there should be liability in that context. We do, my Lord, give content to Regulation 15C2. We set it out at paragraph 98 of our case, MS 103, so that it can bite in a no-fault liability context.
We have an entire minute left.
More than is strictly necessary, my Lord. May I hope to use it wisely? My Lord, my learned friend started off with it's common ground that the hotel wasn't at fault. I think one needs to take care with that. It's common ground that the claim on the basis that hotel was directly at fault in a selection of N was not pursued at trial. It was never conceded, should vicarious liability have any part to play in this, that there was no vicarious liability, and that was maintained on appeal and is maintained in our written case for this appeal. I know I've omitted to get to it orally, but it's in our written case that if for whatever reason the court is minded to consider vicarious liability to be a relevant concept, then following Muhammad, and it's English law for these purposes, Sri Lankan law equals English law, N's conduct renders the hotel vicariously liable. But in any event, we are concerned here not with the decision not to pursue a claim for direct liability based upon direct liability in what would be negligence, Sri Lankan and English law, negligence by the hotel. We are concerned at this point with Regulation 15C 2 and the meanings to be given to the word fault and foresight and forestalling.
Supplier?
And supply. I mean, I don't wish in any way to limit it in that way, but absolutely, my lord. And for these, as my Lord Lloyd Jones has already observed, one has to go back to recognising the regulations follow the directive. The directive will, of course, have ordinary autonomous European meanings attached to it. And so,
Is that clear in your favour?
no, I do, but I mean, and I've already given my submission that for the purpose of supplier, it doesn't matter, because you're not focusing on supplier, you're focusing on the supplier of the service. And once it's recognised that the service was faulty...
It does matter so far as the basis on which Lord Justice Longmore dissented is concerned. The scope of the meaning of supplier is critical there, because as I understand it, he concluded that N should be regarded as a supplier.
He did, my lord, and that's part of our case, but it's also our case that if the hotel's a supplier, for the reasons I sought to enlarge upon, so when we appealed on the full basis. So it's whether or not it's the minority judgment in the Court of Appeal is the right answer, or the right answer is simply that which is promulgated by this court. Doesn't matter, because it doesn't matter who the supplier is.
I am left with concern, so far as that particular point is concerned, as to whether this can be considered to be Act Clear. The scope of the meaning of supplier is Act Clear. And I understand there's no appetite for a reference in this case, but we are under certain constraints.
My lord, I sidestep it. I sidestep it by saying it, but by saying it doesn't matter. If it was critical to determine, that I would understand, but it isn't.
Yeah.
My lord,
Concentrate
I'm
on
very
supplies.
grateful for the extra time, which in the ordinary way of counsel I use.
Not at all. Mr. Stevens, when do you think you can get your submissions in?
I have 7 days, my lord.
7 days seems reasonable.
Great.
And I know that you will keep in mind that you mustn't replicate any of the arguments presented on behalf of the respondent.
I shall.
7 days for you too, Mr. Weir. Right, so 7 days for the intervener and 7 days for reply. We're very grateful to all who have assisted in the presentation of this very interesting and obviously a very sad case. And after we've considered the further written submissions, we shall deliver our judgment in due course. Court is now adjourned.